welcome to the Great Trials Podcast with Steve Lowry and Yvonne Godfrey. Yvonne, straight off the operating room table, straight into the podcasting booth. How are you doing today?
I'm doing good. As I was telling you and our guest right before we started recording, it was not the fun kind of surgery. Nope.
Right.
No fun drugs, which I'm just kidding about the drugs for legal reasons.
Yeah, exactly.
But I'm doing fine. I'm glad to be back in the podcast swing of things, and just that my medical issues didn't take time away from the podcast.
That's right.
What I'm really
right.
That's what I'm really relieved about.
I mean, you had the morning off. I mean, what else do you want?
off.
Yeah.
That's what I got to do to get a day off around here.
Exactly.
I didn't even need surgery.
Right. Yeah, exactly. Well, that's enough about your medical issues. Let's introduce our fantastic guest today. So we have Sarah Stempky-Kime, who is the managing attorney at Christensen Law up in Southfield, Michigan. You can look her up at David Christensen, that's CHRISTENSEN law.com. Sarah, how are you doing today?
I'm great. How are you guys?
Very good. Very good.
Doing good. And I want to make one point of clarification, Steve. There's never too much info about my medical issues on the show.
I know. It's not the first time we've talked about your medical issues.
No, that's what I want to make sure when you say that's enough, it's never enough.
Right. Exactly.
Okay.
That's like a day off, like when people refer to maternity leave as vacation, right?
Right. Exactly.
Yeah. You're like, I don't feel rested.
Yeah. That's always something good to say as a managing attorney. I'm sure you know, Sarah.
One of my colleagues just mentioned it to me the other day and referred to it as, when you were on vacation after you had Wilhelmina. And I'm like,
Yeah.
You want to go back in your office and rethink that?
Right. Yeah, exactly.
Take a minute, start over.
Oh, well, very good. Well, Sarah, let me tell everybody a little bit about you. As I said already, you are the managing attorney at Christensen Law in Southfield, Michigan, a graduate of Alma College, and then went to Michigan State University Law School and participated or graduated from the Trial Practice Institute, where I understand you were in multiple mock trial moot court competitions, got to the finals in several national competitions in that. And since you have graduated, have been involved in just a number of huge cases, including the one that we're talking about here today, which was the second largest verdict in Michigan for 2014. You're on the Michigan Association of Justice Executive Board. But I found interesting, I saw that you grew up on a Christmas tree farm, raised pigs, played hockey and soccer, and then and still are active in soccer. It sounds like you play all year round, both indoor and outdoor leagues. Is that right?
I do. I can't let it go. Gotta hold on to those glory days.
Yeah.
Approaching my 40s. No, just like Taylor Swift, I grew up on a Christmas tree farm, and my dad always brought trees down to Metro Detroit when we were growing up, and he still does. So now I live close to the lot. We can help out on the weekends. And whereas I absolutely hated it while I was growing up, now I actually find it kind of charming, and my kids love it. We go and spend way too much time there in the winter. And then, I play soccer year round. I kind of dropped off the co-ed scene shortly after I had my first kid. I was like, you know what? I don't need to be playing with a bunch of dudes that are trying to live out their glory days.
That's right. That's right. Yeah.
I don't need to go up for a 50-50 header against some guy. So
right.
Mostly I stick to women's leagues now, but it's a lot of fun. I've been playing with some of the same women now for, I would say, I don't know, 5-6 years, the same exact team. So it's just a lot of fun. And I really hate running, like with no purpose, unless I'm chasing something.
No running in soccer, right?
Yeah,
I mean,
so if I'm playing soccer, or basketball is the other sport that I like to still play, then I don't hate running so much. But you will not find me like grabbing my phone and going out for a 10-mile run. That's not my type of workout.
That's Steve. That's Steve all the way.
That is, I do like to go out for my runs. I'm not fast, but I will make it. But I was just gonna, so us soccer experts, Sarah, we have to stick together. I coached my daughter's soccer team from the time when she was 5 to about 11 years old. So I consider myself an expert.
Sure.
I did become an expert on what offsides was. I didn't know before that. Now I understand the rule well, I think.
Yeah, I mean, you don't really need to know anything else if you know what offsides is.
Right.
You got it all figured out.
That's right.
I usually play center mid because I am just as much of a control freak on the soccer field as I am in life. So I like to have my hands in every aspect, offense, defense, and be the one distributing, as I kind of do in the office as well. That's sort of my role here.
Yeah.
And of course, playing center mid means you don't run at all in soccer. I mean, you only go both ways. So,
but I'm telling you, if you're chasing a ball, it doesn't count as running.
That's right. That's right.
Yeah.
I should also mention, Sarah, that you are involved in multiple charitable projects, including the Brain Recovery Project, Detroit Horsepower, and Impact 100. And I thought was also pretty cool is that you have started a business accelerator network for female attorneys and paralegals. So that sounds really cool.
Yeah, we are. We're just getting that off the ground. There are quite a few networking groups for lawyers and females, but this one, we wanted to be a little bit more intimate, and we wanted to focus on a few different things, philanthropic, but also business growth. And part of that business growth model is something we've been trying to implement here, which is growing your business by beginning with changing your culture within. And I think that's something that a lot of law firms are really slow to do, even though around us, workplaces are changing, and the way that your workforce views being in the workplace is changing as well. And we have to keep up with that, or else, turnover is going to just, I think, just skyrocket. And a lot of law firms have been doing the same thing for 40 years, 50 years, and assume that they will continue being successful at it. But I think as employees start realizing that there are other places that value the way that employees work and employee happiness and engagement, and and that encourages buy-in from your employees, I think that things are really going to change. And part of the focus of the networking group is to change workplaces for women, but also to elevate women who are in positions of leadership.
Yeah. Well, it's such a great great thing to do. I mean, especially with trial practice, which is, for so long been such a male dominated industry, that we definitely need to get much closer to equality, because we're not near that yet. So
sure. I mean, as you know, trial practice, litigation, personal injury are still so male dominated, and so many of the firms are, have existed for decades with white men at the helm. And I think that where you're seeing a shift to women in leadership, I think you're seeing a positive impact on the business, both from the outside perspective in marketing, and also on the inside with how you're treating your staff and your coworkers. And really, I worked at a place where it just wasn't a nice place to work. No one cared if employees were happy. There was just so much cattiness and little cliques and this and that. And no one asked the employees what they wanted or what they cared about. And not all employees care about the same thing. And then we came here and we thought, oh, well, we just want a nice place to work. We want people to be happy. And when we were small and we kind of wanted the same things, that was easy. But as you grow, you realize that what makes one person happy and motivates them is not the same thing that motivates and makes another person happy. And so you really have a juggling act going on. And it's a work in progress, but we are committed to working at it. So, that's our number one goal here.
Yeah, well, let's talk about this case. This is a really good case to talk about. The name of the case is Vaylma Dorado versus McCoig Concrete Co. Leonard Wells. There was also Rockaway LLC and Brownstone Primo Concrete. It sounded like the main defendants were McCoig Concrete Co. and Leonard Wells, but it involved in this case was tried in June of 2014. It involved a collision between a cement truck and a Volkswagen Jetta that happened at 9:35 a.m. on September 17, 2010. Vaylma, who is 36 years old, she was an employee at, I think, Guardian Alarm, and she was driving on Telegraph Road and getting ready to make a turn. And basically, this concrete truck going approximately 50 miles per hour. And I think there was evidence that the driver was distracted looking at paperwork or something like that, wasn't watching where he's going, and he just ran straight into the back of Vaylma's Jetta and pushed her into a utility pole and caused serious injuries. She had a number of, although this was a big part of the dispute at trial, but she had a traumatic brain injury, severe traumatic headaches, spinal fusion and neck surgery, shoulder surgery, tremors in her hand, two more spinal fusions at L4, L5, and then at L5, S1, and then a hip fusion at her sacroiliac was fused as well. So just multiple injuries. And this was an admitted liability case, which we've talked about this a few times on the podcast, and I always like to remind our listeners that admitted liability cases, I guess from first blush, might sound like they're easier, but it's a tactic by the defense in order to put the heat on the plaintiff, to make it all about the plaintiff's injuries and how they're just being greedy, trying to get too much money for what they for the harms they've suffered. But that didn't work in this case. This was just a fantastic verdict. Total of $17,800,000 for Vaylma. That was in June of 2014. This was tried in Wayne County, Michigan. Wayne County, that is is that Detroit?
It is, yeah.
Okay. Yeah, so tried in Wayne County, Michigan, June of 2014. And as I said earlier in the show, this was the second largest verdict in Michigan for 2014. So just really fantastic work. And Sarah, I know you and your law partner tried this together. Talk a little bit about how you just when there is an admitted liability case, how you address that and some of the problems that come up in trying cases like that.
Yeah, so like you said, in admitted liability cases, the defendant's always going to try and make it seem like, well, we've said we're sorry. What more can we do? The plaintiff now just wants to come and ask you for money. It was just an accident. And we admitted that we shouldn't have done that. So really, what more is there? And here we had some nice facts because we had sent requests for admissions early on that they denied. They had also denied the counts of our complaint that alleged negligence. And actually, we had to refile the case just as a procedural matter. And so we had even a more recent complaint and answer that was just a few months before trial, where they, again, probably pro forma, but again, denied all the negligence counts. And that was just a few months before trial. And this case had been being litigated for years. So they couldn't quite get away with the "we apologized" and, now what more does she want type of attitude, because we had discovery responses where they denied negligence. We have their answer where they denied negligence, and they only stepped to admit negligence just right before trial. So it really, I think, backfired because it really came across as pretty disingenuous.
Right. One of the things that I like that there's a number of great themes that you all put into this case, but one of the things I really like that you did is you had evidence that the concrete company had called this a very serious accident in their own paperwork, and then got their truck repaired and back on the road, I think within 2 weeks. So when it came to themselves, they were very quick to act and to make sure that they were, made whole, but then didn't want to do that for your client.
Yeah, and I don't know if you guys have worked with Eric Oliver in the past, but we worked with Eric on this case. He is a fantastic trial consultant, and that was one of the themes that he identified for us early on was they made themselves whole within weeks. Their truck was back on the road, their driver was back to work. They missed no time. In Michigan, we have to be careful of how we talk about profits and things like that because we don't have punitives.
Okay.
But we could at least say that they made themselves whole and got back to work. And Vaylma at the time of trial was still working to make herself whole, and they had not accepted responsibility at that time. They never had.
So I was wondering about that when I saw the facts of this case. So Michigan, I'm sure we've talked about this before because we've had some other great Michigan lawyers on. They don't have punitive damages in Michigan?
No punitives in Michigan.
Okay. Is that because of the auto industry? I mean,
yeah, I mean, I would thank our insurance lobby for that. This has been a gap in our civil justice system for a really, really, really long time.
Yeah.
And I think there was a trade-off for some of our liability laws when they instituted the no-fault system, which has now been sort of dismantled again. But alas, we still have no punitives.
Yeah. I did notice you do have joint and several liability.
Yes.
So that's one thing that Michigan has that we don't have down in Georgia. Everything gets a portion. So, but yeah, that's important. But we'll talk about this case. I mean, I know how much work you put into it, and I know that there were things that, at least at the beginning, that maybe your focus groups had cued you in on that you were viewing as potential weaknesses in the case, and how you sought to address those.
Yeah, so when we focus grouped the case, we wanted to flesh out a few issues, one of which was how they viewed our client. That was probably first and foremost. She was such a sweetheart, but when she got nervous, she cried a lot, which, as we know, can sometimes be a turnoff if the jury has not yet accepted and embraced you and wanting to take care of you. She had a shaky voice. She was very unsure of herself because she had that tremor, so she would sometimes shake. And so, as cynical as trial lawyers are, we wanted to get some feedback on how our potential jurors might view her idiosyncrasies. Oh my gosh, I can't even talk. And so we recorded a video for them. We didn't prepare her before we did that. And I think there's some differing views on preparing your client for your focus group video or not. And we went with not. And so we kind of gave them some really raw footage of her. She also is a lesbian. She has a partner, a long-term partner for a long time. This was 2014, so we didn't know how that would play. We were in a fairly liberal jurisdiction with Wayne County, but still pretty unsure. And then, of course, because she's an unmarried woman and with no kids, then you have the question of damages. And because we have no punitives, what is your argument for large damages when you don't have dependents or something like that they can kind of hang their hat on to give money for? So we really wanted to test that. We also wanted to test the argument that the head injury symptoms took some time to arise and whether or not there would be a strong enough causal link to the crash. Same with the orthopedic injuries. There was argument that they didn't all show up on the day of the crash, and some of them were sort of tangential, like you mentioned, the hip fusion that arose much later, but could be linked to the low back. The shoulder was the first surgery, as well as the easiest linked. They didn't really argue much about the surgery, the shoulder surgery, but that was also probably the most minor injury. And the defense expert on orthopedics basically argued that her orthopedic complaints were because she was fat. And so that was another reason we wanted to show our mock jury her video and then present them with the defense arguments. So we got a lot of great feedback out of that focus group. We also wanted to show a video of her partner because we knew that her partner was going to be our strongest damages witness. She didn't have any family that was going to come to testify, which could have been another landmine, leaving the jury wondering, why isn't this woman close with her family? Where are her family? Why isn't her mom or dad or sister or brother or cousin or anyone showing up here to testify? So we knew that we had to rely on heavy damages witnesses that were friends, former coworkers, but mostly it was going to be her partner who was by her side through all of this. So we did same thing. We did a raw video of her partner. What we wanted to test there was her personality style. She was always tended to be the tougher one of the two. I think she tried to really protect Vaylma, which we loved about her, but it sometimes made her come across as defensive and a little angry. And we know that juries don't always react positively to angry people, whether or not that anger is substantiated.
Right.
So that was something that we wanted to hear from our mock jury on.
I was really curious. Well, before I ask you about this, how far before trial did you focus group the case? And at that time, did you think that you were going to have to go into the issues on liability as well?
At the time we focus grouped the case, I think it was about a year before trial. We did not focus much on liability. I believe we presented liability as though they would have to decide it, meaning they would have to answer the question on their mock verdict form, but we didn't play the defense role as like, we're here to defend on liability, because we knew that it was likely going to be more of a side issue that was just kind of thrown out because they didn't have anything on liability. And so we didn't want to have a big focus on who's at fault. Of course, your jury, just like your mock jury, just like your real jury, asks questions about liability, even when they're told liability is not an issue.
Right.
But we still had them answer the question on the verdict form and gave them the facts of the accident exactly as it happened. And of course, they immediately want to see the police report,
right,
hear from the police officer, find out what Vaylma was doing that she should have been doing differently inside her car, even though she was literally sitting still facing forward, but they got past it.
Right.
Yeah.
So our listeners don't have the benefit of seeing some of the pictures that you sent us and the still of the video. And in looking over that stuff and kind of your summary of the issues that you addressed with the focus group and what some of the defenses were, the weight thing really, number one, kind of pissed me off because I feel like the same thing does not happen as frequently with male plaintiffs as it does with female plaintiffs or female injured people. But I also, in looking at the video of her, or the still anyway, I don't. It's just so our listeners know, she did not look to me to be a very large person, and so I wasn't sure how much of that was legitimate and how much of that was just kind of trying to paint her as less likable or lazy or somebody who wasn't helping herself.
Yeah, I think that is true. I mean, because that's what happens, right? That's the reason why someone on a defense points out someone's weight, is because they're not only implying that there's stress on the joints, but they're also implying that
right,
they're lazy, that they're unmotivated, and that their life is not worth as much. But Vaylma, and because it pissed me off too. So I don't want to give credence to it as though in a plaintiff's presentation matters, but we know it does. And she happened to be, she presented wonderfully. She always was like dressed very nicely, and she took great care in how she presented herself. And she was clinically overweight by definition, but she is not someone that comes across when you see them, the first thing you think is they're morbidly obese or even obese. And so that was a really poor miscalculation on their part, probably due in large part to the fact that their expert who gave these opinions had never met her. So she did a records review and reviewed the radiological studies, because that was what she was. She was a radiologist. So she took this and, said, here's all this adipose tissue, and this is really wreaking havoc on her joints and stress on her back and her hips and all of this. And any time she could, this is kind of an aside, but in her testimony, anytime she could, she would say, and look at this thick layer of fat here next to the spine, or next to even in the shoulder. And it really, I think, backfired. And it did it with our focus group too. They didn't like it. And we didn't even have the advantage of playing the experts' depth transcript for them because it hadn't yet been taken. But even just reading the report and us giving that argument, I think I played the defense at that focus group, and they did not like it at all, and which we were happy to see, because it really offended us. But we wanted, of course, to take the emotion out of it and know how it affected objective observers.
Yeah.
Right. Do you typically, so you're focus grouping the case when you've got some of the facts, but as you mentioned, there's some things that are still to be done at that point. Either some of the experts hadn't been deposed, or you didn't have their video or their transcripts back. Is there a general time frame in which you like to do your focus groups in advance of trial?
Sometimes we'll do more than one, just depends on the trial. In this case, I will say that there were like a bunch of smaller side issues, but there wasn't like one big glaring issue that we were thinking we need to test this and figure out how to get around it. And so because of that, I think we did it a little bit earlier than we may otherwise have done, because we just wanted to see what is it about this case that we aren't seeing, number one, and number two, could the jury give us some ideas of how to maximize our damages, because I felt like we were kind of lacking in that argument a little bit. And so those were the reasons that we focus grouped it earlier on than we might otherwise have done.
Gotcha. Because I feel like you did have, you had a lot of the hurdles with damages in terms of, you're not going to get into liability as much. So you've got that. And we talked about the strategic reasons behind that. You've got all the issues that come with some of her injuries, including the brain injuries that I'm sure we'll talk more about, that are especially, I think now there's a lot more awareness in the general public than there was then about things that are connected to traumatic brain injuries that the average person does not know. And then you also had, I was just wondering if this was something I saw as a products lawyer, and whether this was something that came up at all, which was that looking at the pictures of the Jetta, it didn't look that bad. Her vehicle didn't look that bad, which is not to say anything about her injuries. We all know how that works, but I was wondering if that played at all either into something that the focus group said or something that you felt you had to manage at trial.
It's so funny you say that, because we are always so paranoid about the pictures that we give to a jury. Even if you think that you have the best damage photos in the world, you're going to give them to someone, and an engineer is going to sit there and be like, well, I don't really think that part of the car was smashed enough for her to be hurt that badly inside. And so that is something that we wanted to get feedback from the mock jury on always, because here we had two impacts. So the cement truck rear-ended her and then pushed her into a pole. So we had a double impact. And the rear end of the Jetta looked pretty bad. It had like the dirt and whatnot gathered up into the trunk as it's being like accordioned into the telephone pole. But when you looked at it from the front, you couldn't see any of that. And so of course that was the view that the defense was showing the whole time.
Right.
So, you know, it can be deceiving. And, you know, sometimes you play little tricks, like when you have a photo that has tested really well, you'll like prop that up so that the jury can see it through the whole trial, even when the defense is presenting their proofs or whatever,
right.
you know. But of course, we definitely wanted to get feedback on that. And also that was one of the reasons why in one of the demonstratives you saw, we made it like the cartoon cement truck and the cartoon car, because it takes away some of the tendency to analyze the actual images and focuses on the fact that there were two direct impacts to this woman as she's sitting in a tiny little car that is being careened into by a giant cement truck.
Yeah.
Right.
Yeah. That demonstrative I thought was very effective, but it shows a 66,000 pound concrete truck and then a 2,000 pound Jetta. So of course, if he's going 50 miles per hour in these 66,000 pounds, I mean, that's a lot of force. And yes, the Jetta in the back, I thought looked pretty bad, but yeah, from the front definitely didn't look that bad. But yeah, I could see why they would want to show the front more. I was curious about the defense expert who you said, I can't remember if it was a radiologist or an orthoped. But you know, so were they trying to say that all of these injuries, like the neck fusion that happened, and then the fusion at L5 S1 and L4 L5, all of that was going to happen no matter what, even if this collision hadn't happened?
Isn't that an argument that totally defies logic? But yes, that is exactly what they were trying to say, is that all of this was degenerative. And this woman, and you saw the demonstratives where we had the treatment calendars, and we showed the calendars of her life from before the crash and after the crash, and what her days looked like before the crash, which is, I think she had like a dentist appointment and a physical 1 year. And then after the crash, like more than 50% of her days are filled with therapy, doctor's appointments, surgeries, etc. But that was the argument, that her injuries were all, the only one that might have been related was the shoulder. And the radiologist didn't actually concede that. That was the defense. The defense attorney said that at trial. Okay. But that it was all degenerative process, either degeneration based on age, weight, or the combination of the two. And I always find that humorous, because that assumes that at some point, if you take away the argument that she's lying, and there was no argument that she was lying or faking or malingering, then you believe that her pain is real and that she's experiencing pain. Then you have to then assume that your jury is going to believe that the pain onset was the same exact day as the accident, and would have happened regardless of whether she was smashed into by a 66,000 pound cement. Yeah. But that's what it was, essentially. They said that any, of course, soft tissue strains or sprains that happened immediately after the crash would have gone away, and that the need for surgery was not anything related to the accident. They didn't have a surgeon, so they didn't have an orthopedic surgeon to say that she didn't need surgery, though the radiologist was permitted to say she didn't think any of these injuries required surgery, which is something, of course, we tried to argue against. Someone who's never operated on someone in their entire life, why is she able to give an opinion on surgery? But the judge let it in, and it was fine because it sounded ridiculous.
Right. I was thinking about that when you were talking about how she was pointing out all the adipose tissue and how much damage this does. It's like, well, what about the 66,000 pound truck going 50 miles an hour? I mean, does that do anything?
Right.
Yeah. And this is one of the few cases where this woman had no history that could be construed contribute to this. I mean, and that doesn't happen very often, but she had nothing in her history as far as like an achy neck at some point, a headache, a backache, nothing. And so that was what we did with the radiologist. Like, how was she functioning the day before this truck crashed into her? I don't know. Like, how was she able to perform her job? Was she able to sit at her desk? Was she able to hang out with her friends and hang her Christmas lights? And I mean, of course, we were able to go down that road, and this radiologist had nothing to say, but I don't know. But it really, I say it defies logic, but the argument is made all the time, and juries buy it all the time. So, at some point it works, but here in the absence of any evidence at all that this woman had even an ache or a pain before this crash, I just feel like it fell flat unless the jury was going to believe that she was a liar and assume that she was like harboring all this pain from before the crash, but never wanted to see a doctor. And then after the accident, all of a sudden decided to see every specialist in the world. And, all of a sudden her pain was too much to overcome.
Yeah. It's like, I mean, it was her lucky day. I mean, she's like, I'm so glad this happened today. Now I can get all this stuff taken care of.
Man, I've been waiting to get that back surgery, but until that truck hit me, it just wasn't the right time.
right. Exactly.
How was Vaylma as like, I think a lot of times with our clients, we can, you can certainly deal with it, but sometimes you have the issue where you've got somebody who's just not good at communicating with their treaters, or doesn't want to be a complainer, or is not a good historian for themselves. How we talked a little bit about what she presented like, or might present like to a jury, but what was your impression in terms of dealing with her treaters on that? Because I think that's a lot of times that's something you have to deal with in a case where somebody is really badly hurt, but they don't like to talk about it, or they don't trust doctors, or all kinds of other stuff.
She was really good at, and I think her partner helped a lot with the history to her orthopedic doctors. And luckily they were all in the same group. So they had really nice chart notes and were able to adopt each other's history. And that was great. She was not so great with the head injury. And that was part of the argument, was that the onset was delayed, but really it was more just her coming to terms with the deficiencies that she was experiencing and not wanting to acknowledge. And then you've got, with traumatic brain injuries, a lot of the times it's loved ones who are the ones who notice that their loved one is suffering and that they have experienced changes. But then there's always this dance because they don't want to point it out, like, hey, hey, honey, I noticed that you're forgetting your words, or it seems like you're a little bit more irritable. And so they all, you kind of dance around each other until someone finally says something. And that was the case here. So finally, Carrie said to her, I think you probably need to go and see someone about the difficulties that you're having emotionally, especially at first. It was emotional, and some dizziness and nightmares and classic PTSD stuff, but also signs of a mild TBI. And as you mentioned earlier, Yvonne, like, this was 2014. Awareness around mild traumatic brain injury was still not really there. And we've gotten better in the last 7 years. I mean, I think people realize now that concussion isn't just a concussion. And that's what we had here, is they kept trying to say, like, if anything, it was just a concussion. And, doctors agree that concussion and mild traumatic brain injury are used interchangeably, but as a society, we still accept that a concussion is just a minor bump on the head. Right. And so when we're trying to downplay what someone is experiencing as a result of an impact to the head, we often say, oh, it was just a concussion, even though that is clinically interchangeable with mild traumatic brain injury. But when we view someone on the outside as walking, talking normally, I'm using quotations for normally, because I hate the word normal, we don't, we are overlooking the great suffering that goes along with something that is classified as mild, because mild does not mean mild effects on a person's life or independence or cognition.
Yeah. One of the things I saw in your in what you sent us was that the defense, I think, tried to point out from some of her medical records where maybe she denied some of the symptoms of a head injury, or that would go along with a traumatic brain injury or head injury. How did you? And I think what I remember is I think she denied dizziness, I think she may have denied headaches at one point, and then denied memory loss and stuff like that. How did you handle that at trial?
So that was actually a really fun piece of this trial, because she went to see a neurologist, and I would put air quotes around neurologist for him too, where he put in his chart note, she denies a litany, everything that you just said, denies. And that was the document that they gave to their expert neurologist, the defense gave to their hired DME. But when you got the full chart note from the treating neurologist, it came with like the human drawing intake with circle the symptoms that you're experiencing and draw where you're having difficulty. And she had circled dizziness, memory loss, difficulty sleeping, but he either just hadn't paid attention or was wrong. I don't know what happened, because we didn't bother talking to him, and he was impeached by his own record. But then also the defense expert was impeached as well, because he said, well, the only credible doctor in this whole bunch is this doctor here. And look, he says she was denying all of these things, and this was the closest in time to the accident. And she wasn't having any difficulty with memory. She wasn't having any dizziness. She wasn't having any difficulty concentrating. And then we handed him the intake sheet, which he did have. He had it. He just looked over it and concentrated on the chart note and said, this shows that she was having literally all of those things that he put that she denied. And that didn't go over too well.
Yeah.
That does sound fun.
Yeah, that was one of my favorite parts of the trial, because we of course knew it was in there the whole time, and we knew that the defense had gotten the records too from the copy service, but they let their expert go down that path and really go all in with this one chart note. And it really, really backfired. And then their expert kind of, he of course kind of backed off, even though he is a very, very seasoned expert. And they were left a little high and dry from a neurology standpoint.
Yeah, one of the things I learned as a young lawyer, and it's a practice pointer for young lawyers, is that these medical records, a lot of times they come as part of a program, and they, doctors, because they are busy people and they don't have time to constantly fill out paperwork, will pre-fill out a lot of these. And so they won't always change it. So you'll see stuff in there that clearly doesn't go with the patient just because they haven't deleted that or taken that out. So I always make it a part, especially in medical malpractice cases, to get into questioning about what type of program they use for their computer records, and whether or not any of it's already filled out, and what they have to do to make sure that the records are accurate, because you see it all the time.
That's a great point. And even when you're looking at a record for the patient, it'll have neurologic, and it'll say experiencing headaches, status post accident or whatever. But then you'll go down to orthopedic and they'll do a review of symptoms, and they'll put denies headache on the very same record, just because they're rushing through, or they're not attributing the headache to orthopedic symptoms. And defense tries to run with that. But if you know your records better than the defense, which you should, you can have some fun with it.
Yeah. I feel like I learned the same thing doing, and you do have to do this a lot of times. If you're screening a potential case, you spend a lot of time on the discharge summary and on the admission paperwork, but then just because of that pre-filled thing or that rushing thing, you end up, when you really go through it, it's in, these hundreds of pages of progress notes and things like that you don't really want to go through. But a lot of times that's where the good stuff is, because it's not been filled out. It's somebody who's just having to write it from scratch, and just spending the time to go through that is hard. But a lot of times that's where your best stuff ends up being.
Yeah, that's always the most tedious part of trial prep for me, is going through every single page of records. But in what we sent you, we attached a couple pages from the medical chronology that we do in every case, which is a line by line document that has every single visit, every single PT. And so that forces us to look at every single one, because as you said, some of the best notes are like in your physical therapist or occupational therapist notes, where they're saying what the patient is experiencing that day. So to the extent that you're trying to avoid having your plaintiff whining on the stand, you can do it with your damages witnesses and getting what they're experiencing, but you can also get it from the medical records. But that chronology that we do forces us to comb through every single page of every single record. So then I also keep a shadow document of things that I view as negative. But then with my chronology, and sometimes it turns out to look impressive. Like in this case, it was like 10 pages, single space. Sometimes it's not, but then I always have it to know the date that something happened. And I put just the date, the treatment facility or doctor, and then like one line about what happened when they were there. And then we are usually able to admit it as a 1006 voluminous records summary. And sometimes I have to take out the last column of what happened when they're there, and it's just the doctor and the date, but it gets the point across for just what your person's going through, because you can't outline every single record, every single treatment visit at trial. But when you're trying to convey the sheer volume of visits and what their life has looked like when you're trying to contrast pre and post crash, I think it really makes for a good demonstrative or exhibit if you can get it admitted.
Yeah, it's so huge. And I can't believe how many times like we'll finally make a good one of those, like close to trial. And it's so useful. And you're like, man, I would have loved to have this a couple years ago.
Yeah.
Totally. Yes. I know. I someday I'll do them as records come in or something.
Yeah.
Like a working document, but right now it's pre-trial.
Whenever it happens. Yeah.
Well, that reminds me of another demonstrative I saw that you use. I'm thinking it must have been in closing, but it was basically where you had taken every treatment that she had had, whether it was a surgery, and you put what the value of it was, and I think you might have even put a pain and suffering value to it. And then you put a future pain and suffering value in it. I mean, it was a long list, but it was a really good way of sort of, pointing out everything that she had to go through because of this, and then how the jury could put a value on each of those and then come up with their verdict that they did. And they must have followed it pretty closely, because I think the numbers that you had at the bottom of it are fairly close to the number at the ultimate verdict.
You're right. This was the first case that we did that in, actually, because we were trying to, that's always the challenge is your ask at the end of trial. And juries always want a suggestion, but then they're sort of skeptical of your suggestion and what's the foundation for it. And here we didn't have anything, we couldn't ask for medicals. We don't ask for punitives. We can't. So we're left with non-economic and future wage loss. And so we just sat there and thought, what if this woman has been through so much? What if we just go through and we really got pretty granular with it, like with breaking down injections and chronic pain syndrome and the symptoms of the traumatic brain injury and the headaches. And we really tried to be realistic. It was a big number, but as you said, they gave us exactly what we asked for. And so we gave them past and future. And if something had resolved, like the shoulder, we obviously didn't ask for future. So we tried to, we explained it as we went along, just so they knew that this was a realistic figure and not just something we were pulling out of thin air. Though, of course you are. You can't put a dollar sign on someone's life, but you have to at the end of a trial. And so does your jury. Yeah. And I think that was the best way that we've come up with so far to do that. and if they're with you, then you're going to arm your plaintiff jurors with something that they can hold on to and say, well, this is what they've suggested. And if they're not with you, then they probably think you're nuts.
Well, even then, I mean, because, assuming you got a few jurors with you, even if the ones who aren't, it's going to be hard for them to go line by line and say, oh, this one doesn't count. This one doesn't count. This one, I mean, it's just, it's a great document to put together. And I also was going to mention, so the verdict form, basically the jury goes through and puts an amount per year, on like for lost wages, lost future wages, and then the same thing for pain and suffering or non-economic damages, but they don't add it up. So I was thinking, so when you get this verdict in, is somebody sitting there with a calculator going like, well, how much is all this? Because there's just all these lines that have like 300,000 on them. And then I was like, well, what does all this add up to?
I sat there, and when they started saying the same number over and over, I just started making tally marks.
Right.
And when they got done, Dave was like, do you have any idea what this was? And I'm like, I think it was like 12 million. And it, was like 17.8 because I couldn't keep up.
Right.
But you're right.
Yeah.
The verdict form did not give them a total. So
that was crazy looking. And it also, I had a couple questions about that as well, because it had blanks for each year. And I was also wondering, okay, how many blanks do you get? Do you get them from like the mortality tables, or was that some sort of stipulation?
Yep, exactly. The mortality tables
okay.
is where they come from. So unless there's evidence to deviate substantially from the mortality tables and life expectancy, then that's what we're going to go out to.
And is that how it's always done? A blank like that, year by year by year in Michigan?
Yeah, for future pain and suffering, that's how we do it.
Wow.
Because they can stop whenever they want, or I mean, I guess conceivably they could skip years and decide that they're not going to start suffering again for 5 years out. They can do whatever they want that makes, I guess, makes sense to them. But and also they could decrease it, so it wouldn't have to be the same number for each year.
Right.
They might start titrating down as they think that the suffering would decrease, I suppose. Although our argument is that as you get older, it's only going to increase because you're in a compromised physical state.
Right. And I could see, I mean, I think I like it. I think it would be really hard to sit there and have a verdict read to you that way. But I do like the sense of, because what can happen otherwise is that, you have your number or your range and you're trying to get the jury to think about it by day or by month or by year or whatever. But at some point it does just seem like if it's just one blank, that it all just kind of gets telescoped together, versus if somebody's actually got to go with each blank and think about the dollar amount that's going on that for a whole year, for all these years that somebody's going to live with this pain. I changed my mind. I do like it, but I think it must be torture to have somebody read it that way and be like, where's this going?
You're right. I mean, a couple $100,000 may sound like a lot at first blush to someone, but when you spread that out over 40 years and it ends up being less than 10 grand a year, and if you're really examining what someone's pain and suffering is worth, and if you agree that all of these injuries were from the crash, then $6,000-7,000 a year isn't enough to compensate her for that. And we had testimony that she was probably going to need the other hip done. And of course, as time goes on and you've got fusions in your spine, you're probably going to need adjacent levels fused at some point. So she's probably looking at more spine surgeries down the road. And that's how it's done here. So I don't have a choice to do it a different way, but I do like it in that you're forced to really think about what a year's worth of pain is worth, rather than just, this is a lump sum. It sounds like a lot. That's probably enough. So we'll just give her this.
Yeah, no, I like it because it forces them to think about, each year and what each year is valued at. And so, and I also have to think that in the, when you get a plaintiff's verdict and you're celebrating afterwards, it's probably kind of fun just to go through there and add all that up.
If it's a good verdict.
Right,
yeah.
exactly.
Yeah. If it's like $3 a year.
Right, yeah, that's not so much fun.
Right. I did want to ask in terms of damages, as Steve mentioned, there was also, something on there for lost wages. And I was just hoping you could speak a little bit more about what you did. I think you had a vocational expert who basically just talked about what she could do, or more specifically, what she could not do, and to sort of address this issue of, what you're normally going to get is, that somebody can't do any job, like there's no job they can have, they can't work as a clerk. So talk a little bit about that, how you dealt with that issue of her not being able to really do any type of work.
So we had some really good testimony from her ex-coworkers, just because it was after the crash and she hadn't returned. And they sort of turned into experts in her job, but also as non-economic laid witness damages experts, because they were able to kind of sit there and be like, well, this is what you've got to do, and you've got to think quickly to respond to the alarm. And oh yeah, Vaylma, she was always on top of it, and people are scared, and she's on the phone with them, and she's thinking fast, and she's getting the correct people out there. But then the nice thing is that these are her friends who have stayed in touch with her after the crash. So they're able to say, no offense to you, Vaylma, but as I sit and talk to you now, I know that you're not quick enough to deal with these types of emergency situations. And so those witnesses for us were like dual purpose, which was awesome. And so, yeah, we had our voc rehab expert who, they digest the medical records and say, based on what's in here, this is what she would be a fit for. And here we kind of had all angles covered, because she couldn't do a sedentary job because she's got, this tremendous amount of back and spine pain. She can't do a physical job that requires lifting or any sort of manual labor for the same reasons. She really can't do any job that requires critical thinking or any sort of quick decision making, or any type of situation where she's put on the spot and has to analyze something. So it really was a situation where we really could combat any argument of, well, she could do something, right? She could stand at a cash register and check people out, or do something like that, because she really truly couldn't. Her economics were not a huge number, and at some point I'm sure we discussed letting those go just because they were a lower anchor. But because her job was so important to her, the nice thing we had too was these awards that she had been given at her job that went right into, fit like puzzle pieces into the rest of our damages testimony, like how social she was, how she always liked to dress her best, how she always liked to plan parties. And so she had gotten these awards from her job, like dresses to impress, or like, something like that, these cute little awards, or the party planner of the office, or there were pictures of her dressed up. And so I suppose we could have let the wage claim go and still presented that evidence, but we kept it in because it really was important to her. She was not a high earner, but she very much valued her job and gave it her all while she was there. And that came through with the awards that she got, little awards. And we had 2 coworkers testify. And then on top of that, we had, for damages, we had outside friends.
Yeah, I thought some of the photos that you had were really great. It just made her look like she was very energetic, a lot of fun, and just sort of like to do all kinds of fun and interesting things. One of the things I think I read about, that you made a decision in this case where a lot of times the plaintiff will be one of the last witnesses of the plaintiff's case. sort of to bring it all home. But I think you made the decision to call her early in your case to sort of set the table. But talk about your decision there and why you called her early and how that affected the case.
I think that was a little bit of a gamble. We, as you said, I would say normally ascribe to the proposition that your plaintiff is going to go up last and bring it home. But there were a couple of reasons why we got her up early. One, we wanted to get her up before her damages witnesses because we wanted to present her in a more hopeful light, because she was very hopeful and we didn't want her up there talking all about her pain. We wanted her to talk about the things that she did before the crash. We had her talk a little bit about how things had been after, and in a very straightforward fashion. This is what I've done. This is what I've had this surgery. I go to this therapy. I'm trying really hard to do this. I'd really like to be able to cook again. But we wanted the rest of the story, the damages essentially, to come from people who were not her. So we put up early on the surgeon who had done the biggest surgeries, the neck and the back. And I think we might have done one damages witness before her, but we wanted her partner to really be that last witness that brought it home, and she was. We also, quite candidly, were not sure if she would be able to hold it together on the stand. We weren't sure if it was going to be kind of just a mess. She was very emotional, understandably super nervous about trial, super nervous about testifying, talking to the jury. All of it just gave her great anxiety. Her life had been completely turned upside down, and this was basically her shot at redemption for her future. So she felt immense pressure. She was self-conscious of the way that she spoke, with a wavering voice and her tremor. And so we knew that we wanted to get it over with for her, and also just let her partner be the one to carry the weight.
Yeah.
Excuse me.
No, I think that's a great way to do it. And we, talk about it a lot, of doing, good before and after witnesses, friends, family members, people who can talk about, how the client has changed, since this happened, and really let it come through, other people and not through, the plaintiff herself.
Yeah, we didn't have anyone that could talk about her childhood or about her as a young adult. And so that's where those photographs really came. I mean, they were crucial because it really just showed the full life that she had always lived, and not just in the maybe 10 years before the crash that these people had known her. Because she wasn't close with her family. And so we didn't have anybody that we could call to fill in those gaps. And so a lot of her testimony was going through those photographs. We just kind of flipped through them, and she would kind of laugh or, give a little anecdote about what we were looking at. And I think that the jury really liked it. I know they did, because they told us after the fact that they really loved those photos, and they loved her. I mean, they asked her if they could give her hugs after they gave the verdict, and some of them were crying. So they really, she really spoke to them and connected with them more than we could ever gauge as trial was going on.
Mm-hmm.
I'm curious, did the defense try to do much of a cross on her? And was there, it sounds like it wasn't effective, but what did they try to do?
He pretty much went with the typical defense playbook. He crossed her on, he showed the records, crossed her on the delay in onset for the injuries that he thought were delayed. And then spent a lot of time on improvements. After your neck surgery, you went back to the doctor and your pain was down to a 2 out of 10. That's great, and so really mostly just trying to make it seem as though, and that was his argument in closing too, that even if the accident caused all this stuff, she's fine now. So all of the damages are in the past, and we know that the head injury isn't related, so that's worth nothing too. I think he suggested maybe like 100,000 or something, like 120,000. I don't know. I don't remember, but it was like that. Like any damage that has happened, she's gotten the treatment that she's need. It's been great. Her pain is low, and the head injury isn't related. So we good.
Yeah.
Sarah, I wanted to ask you something, just going back for a second about damages witnesses, and you ended up having some who were kind of filling dual roles, like the former coworkers. But something we talk a lot about on the show, and I think we talk a lot about when we're getting ready to try a case, is how many is the right amount? How many, is enough without being too much, without annoying the judge, without annoying the jury? And I was just wondering if you had any helpful thoughts about both who you pick, and then how you decide when you feel like you've got the right amount of testimony.
When we talk to our clients about who we want for damages witnesses, everyone comes out the gate with like 15 family members. And so we always try and tell them like, okay, great. We're going to narrow this down, but I also need non-family members. I would prefer some people that have known you in your professional life, even if you don't keep in touch now, since you haven't been back to work after the crash. We want them to paint the picture of what you were like as a coworker, et cetera. Of course, we've all been in trial when the judge is getting irritated with your damages witness it, and, move it along. Okay. Or how many of these are we really going to have? Are we really going to have 10 people in here? And it's so hard, right? Because that's where your money is going to come from, in the absence of having your client sit up there the whole time, or their spouse, which sometimes works and sometimes doesn't, because of course the argument always is that your family members are going to be seen as more biased. I don't think there's a good way to do it, except for that we try and not like layer them on top of each other. So we try and sprinkle them through the trial so it doesn't seem redundant. And then we try to not have them repeat each other, even though it does, you want to drive home the point that one is making by having another one make a similar point, so that you can say like, well, this is unrebutted. He is the greatest person in the world. But how we try and get around that is always having our lay witnesses be prepared with anecdotes and stories. So we always try and have them have an example that's going to tie in the senses and be able to be imprinted in the jury's memory when they go back and try and remember what that person said. Or when we show the picture, like, hey, this was the person who said that she always put up Christmas lights with Vaylma, or she got home and would always see Vaylma on her hands and knees weeding her garden. And now she walks into the house and Vaylma's pretty much laying on the couch all the time. And so I think when you do it that way, it gets less annoying. I don't know that I can give a number, because there's been cases where I've felt like three damages witnesses were too many, because they just like were not great witnesses and kind of just droned on and said the same thing as the previous witnesses. And then I'm standing up there like, I really want to get these people off the stand. I'm feeling like the judge. But here, I think we had 5, so not a lot, but we just, we'd have a doctor video, and then we'd bring one of them in, and then we'd do something else and throw one of them up. And we tried to sequence it in a way that went along with the testimony that they might be hearing, to the extent we could. Like if they're, if they just heard the neuropsychologist talking about the social issues and the emotional issues, and maybe like your cognitive issues or processing speed or whatever, and then you bring in the coworker that drives home what is required for the job, and you need all of the things that the neuropsychologist just said you don't have, that's a great way to kind of linchpin your previous witnesses.
Yeah.
Yeah.
I like that too, because it's not like juries necessarily think about the witnesses the way we do. You're sort of like, your liability people or your medical people and your treaters and your damages only. And so I like that, because then it feels even more that a witness is speaking to more than one aspect of the case. But I always,
I'm sorry.
no, I was just going to say, you hit the nail on the head. I always struggle with when the judge doesn't want you to have a lot. And what they consider a lot is usually not very many.
Right. Yeah.
Yeah, because they don't care that these are the people that are going to drive your damages. And, of course have all been in the trials where it's basically like, all right, we're waiting for a witness to get here. We need to throw up 2 late witnesses in a row. Right. And sometimes you don't have control over it. But in the event you can, if you can tell your story by spreading them out and sequencing witnesses that complement each other, I think that's going to be to your advantage.
Yeah.
Yeah. I think that's a great way to do it. I did want to talk briefly about voir dire. I saw in some of your presentation that you talk about, how you basically would get the jury talking about the idea of paying money for injuries and whether or not anybody had a problem with that. Talk a little bit about your strategy there.
So I will say that in this case, we had to submit our voir dire ahead of time. And what I submitted to you guys is exactly what we submitted to the judge. He did allow some attorney conducted voir dire, but on a somewhat limited basis. And so what we wanted to focus on, we always want to focus on money for pain, and what problems that someone might have, no matter how small those problems are, awarding money to compensate for someone's pain. And then exploring the concepts of, if you find out that money isn't going to do anything to help that person's pain, do you have any problems awarding money for pain? Because this is our civil justice system and money can't fix everything. You always have those jurors like, well, money can't fix it, so I don't see why I would award a whole bunch of money to this person when I know that it's not going to do any good. And so we always want to explore money for pain, upper limits, trying to weed out your jurors that have upper limits on what they would award, even if the damages were to support it. So then you're also introducing large numbers early on in the case, because you're throwing out huge figures and wanting them to think about whether or not they are capable of awarding those numbers if the proofs were to support it. So even though we were limited in our time, and he did kind of rein us in with, he didn't really want us talking about the facts, he didn't want us arguing the case, we were able to get money for pain. I think we may have lost a couple for cause on the money for pain and upper limits, which was always good.
Yeah.
Yeah. So, and then after the trial, did you have a chance to talk to the jury?
We did. They hung around. The judge did not keep them in the back and ask them if they wanted to meet with us, but they came out in the hallway while we were still there. And pretty much all of them wanted to talk to Vaylma. They all wanted to, I think, congratulate her. And, I really think that they're more invested than I had a gauge on through the whole trial. They were pretty stone-faced the whole time. You try and gauge some level of connection, but can't always. And I didn't with this jury. And then as soon as they gave her the verdict, they were crying, and then they're in the hallway and they're hugging her, and they just wanted to wish her well. Feedback that they gave us, they hated the defense experts, absolutely hated them. They were really offended by some of the same things that offended our mock jury. The argument that her issues were because she was overweight, that she's all better now, that they felt like defense was suggesting that she didn't deserve much money at all, which of course they were suggesting, right, that. Yeah. And they found that quite offensive as well.
Yeah. Well, I mean, this has just been a great discussion and we really appreciate your time. I want to remind everybody that we've been talking about the Dorado versus McCoig Concrete Company and Leonard Wells case. Excuse me, that resulted in a $17.8 million verdict in Wayne County, Michigan, in June of 2014. Sarah, is there anything else that you want to make sure our listeners know about this trial that we haven't had a chance to talk about?
Not that I can think of right now. Thank you.
Well, thank you. This has been really good. Sorry. Now at the end of the podcast, I decided to start losing my voice.
Just in time, Sarah. It's good you didn't have anything else to say.
I had the same thing happening.
But let me remind everybody that we've been talking to Sarah Stempky-Kime, managing attorney at Christensen Law. You can look her up at davidchristensenlaw.com. That's CHRISTENSEN. davidchristensenlaw.com. Sarah, thank you so much for your time.
Thank you guys so much for having me. I really appreciate it.